In August of 2021, Jason Gutterman, who runs the YouTube channel Amagansett Press, stood on the walkway of 1201 East Sherman Avenue, Coeur d'Alene, Idaho, which is a state-run liquor store. The following footage is from his channel.
Yes, sir.
You can film out in the parking lot, but you got to get off our property.
Why's that?
Because you're bothering the customer.
No, I'm purposely staying 20 feet back from the door, not bothering anybody.
We don't care what your purpose is. It's not a purpose that we recognize.
You don't care what? Say that again. I couldn't hear you with that truck going by.
I said, we don't. You affiliated with what?
Well, no, what did you say? I didn't hear what you said.
We don't really care what your purpose is.
You don't care what my purpose is?
No.
Okay.
So you can film from out in the parking lot, but not on our property. That's still on our property.
Whose property is this?
What?
Whose property is this?
The state's.
Right. Which makes it public property.
No.
Sure it is.
Like I said.
What I'm doing is I'm an investigative journalist and I'm working on a story.
Let me see your credentials.
Well, I don't really care what your purpose is, and I'm not interested in having the conversation.
If you don't show your credentials, we're going to call the cops.
You can call whoever you want to call. That's up to you.
Okay.
Knock yourself out.
Let's see your ID.
Let's see your ID. So we have Coeur d'Alene vehicle K27, plate P1594.
What's up, guys?
How we doing?
What are you guys up to?
Can I just ask name and badge number so I know who I'm talking to?
My name is Officer Kayafa.
Kayafa.
Yeah. Hi, sir. Would you like these gentlemen to leave here?
Pardon me?
Would you like them? Are they good here or do you want them to leave?
We do want them to leave. They're standing here. They're filming the customers for...
Okay. So you want them trespass?
Yes.
Okay. Okay.
Thank you very much.
Yep.
Well, you can't, nobody, first of all...
Do you have ID on you?
First of all, let me have a conversation with you. I was not asked...
Right, can I get a cover?
I was not asked to leave.
Okay.
Okay? I'm standing out here on public property. Okay, this is not private property.
I understand, but he doesn't want you in the liquor store, so you could stay in the parking lot. You just can't go on the side.
I didn't go... I'm standing 20 feet back from the door, so... Of course I have ID on me.
I have to trespass you, so I need to formally
No,
get your ID.
No, what are you trespassing me for? I didn't commit a crime.
I have to put it in our system, so I have to ID you.
No, that's not the way it works.
Okay.
You better call a supervisor. It's not the way it works. I'm standing out.
Dude,
Listen,
I don't want to get arrested for disorderly or anything.
There's no disorderly.
Okay.
I'm having a
Do you have
civil
ID on you?
conversation with you. Listen to me.
Okay, I'm
standing on public property.
I understand.
Okay, and I'm not breaking the law.
But they want you trespass from their store, so I need to ID
they can only have me trespass. I didn't go in the store. And a matter of fact, where's their property line? Where's the property line? As far as I'm concerned, I'm not on their property anymore. I'm here talking to you.
Right, and I saw you.
Right, so, well, if I left, I left.
I know. So I need to, they want you formally trespassed. So I need your identification.
I'm not going to get formally trespassed from somewhere I have a right to be. If you're asking me to leave under threat of arrest, then I will leave. But I'm not going to be trespassed from somewhere I have a right to be.
They are trespassing you, so I need to get your identification.
They can't trespass me. There's no lawful basis to trespass me.
It's a private property. They are allowed.
It's not a private property. It's owned by the state.
Okay. Do you have ID on you, or you're just going to do the same thing that he's doing?
I don't have ID on.
I'd like to speak to a supervisor, actually.
Okay.
Yeah, me too.
Okay.
Nobody's breaking the law. I'm taking pictures out in public. You're going to try to trespass somebody and arrest somebody for taking pictures in public? I wouldn't do that if I was you. It's not a good idea.
Before we go into detail about the First and Fourth Amendment rights at issue here, it is important to note that freedom of speech and freedom of press are rights inherent to the people as a whole. So just because a person identifies as a journalist does not mean that he has more or fewer First Amendment rights than the rest of the public. In the case of Cooper versus Dillon, the 11th Circuit Court of Appeals said in a footnote, while case law does recognize that members of the press have an important place in a free society, they are afforded no greater First Amendment rights than ordinary citizens, who are free to publish information as well. In the 2021 case of Saved Magazine versus Spokane Police Department, the Ninth Circuit, which has jurisdiction over Idaho, said, there is no question that news gathering is protected by the First Amendment. Generally, however, a journalist's First Amendment rights are no more extensive than those of ordinary members of the public. Therefore, Yachtin's First Amendment rights were coextensive with those of any other member of the public within the counter-protest zone, and so our inquiry more properly concerns the scope of First Amendment speech rights within that zone. In the 2021 case of John MacIver Institute for Public Policy Incorporated versus Evers, the Seventh Circuit noted, neither the First Amendment nor the 14th Amendment grants the media a special right of access to governmental buildings or information different from or greater than that accorded the public generally. And finally, the Ninth Circuit in Courthouse News Service versus Planet said, the general public has the same right of access as does the media. Just because Mr. Gutterman claims to be an independent journalist does not mean he has a greater or lesser right to access the property, to engage in speech, or to film in public than anyone else. This will be important to remember later in this video.
And a matter of fact, we're not even on their property.
Did you need anything from me?
I'm gonna get your name, yeah, so you're Frank,
Frank
yeah,
Wyason?
when they were sitting on in front of your property.
Yes, sir. And they said they're investigative journalists.
That's fine.
I said, let me see.
I told them what I'm doing. I said I'm working on a story.
Right, so- And they're taking pictures of the customers.
Perfectly legal.
It is?
Of course it is. I'm in public.
I could do that.
I could do that.
Yep.
But they don't have to do it on our
No,
property, right?
right, you know.
I'm not on your property any longer, am
I'm
I?
gonna get people down here and we'll figure it out.
Frank, can I ask you where the property line is?
Frank, what's your last name?
Ryerson. R-Y-A-S-O-N.
Mr. Ryerson, can you tell me where the property line is?
No.
Well, then how am I supposed to leave your property if I don't know where it is?
I said you can go out in the middle of the parking lot.
I'm
This is still our...
I'm right in front of this building.
Yes.
In your store?
Yes.
Okay.
That's not the way it works. I want a supervisor. You're not going to trespass me for perfectly lawful, constitutionally protected activity. Otherwise, you're going to be facing a very serious lawsuit, and I don't want to do that either. That's not funny. It's really not funny. You just threaten to arrest me.
I'm not threatening.
You got to think, you got a lot of serious things going on in this town, and you're threatening me with arrest for taking pictures in
I need your ID so I
public.
can formally put you in our system as your trespasser.
That's not the way it works. I'm not going to formally be in your system. I didn't break the law. He asked me, when you pulled up, what was I doing? I was walking off of the property, correct? I was walking up to your car. I was walking off the property, correct? So he asked me to leave and I left.
Okay.
End of story. I'm not going to be trespassed from somewhere.
Okay.
That's unreasonable. And unlawful. Are you going to get a supervisor for me?
I'm getting whoever's coming down.
Okay. And I wish we could have had a more cordial conversation. You don't seem interested in that.
Well, I've asked you for your ID several times. I'm being very...
Is that a lawful request?
Yes, it is a lawful request.
How do you feel that's a lawful request? It's really not.
Because a private...
It's not a private business.
Their business wants to trespass you. I have to get your
I already
name.
left.
Okay.
They
but
can't trust...
I have to identify you at first. So
No, that's not the way it
totally
works. You're not getting my ID, so get a supervisor down here. That's not the way it's happening. I asked you what your name and badge number was. You gave me your name. You didn't tell me your badge
fine. We don't
number.
have badge numbers. We have call numbers.
What's your call number? What is it?
K48.
K48. Okay, very good. It's not K27? No? You realize this is state-owned property and it's a state-owned business, right? Am I being detained right now?
Yeah, because you're not giving me your ID.
So I'm being detained.
Right now, you're not free to leave. No.
I'm not free to leave. Okay. Very good.
In the case of Brower versus County of Inyo, the police were engaged in hot pursuit of a man who eventually crashed into a police roadblock. The court stated that the use of the roadblock to stop him constituted a seizure. With respect to the officer's show of authority in the chase, however, the court said, the pursuing police car sought to stop the suspect only by the show of authority represented by flashing lights and continuing pursuit, and though he was in fact stopped, he was stopped by a different means, his loss of control of his vehicle and the subsequent crash. If, instead of that, the police cruiser had pulled alongside the fleeing car and sideswiped it, producing the crash, then the termination of the suspect's freedom of movement would have been a seizure. It may well be that respondents here preferred, and indeed earnestly hoped, that Brower would stop on his own, without striking the barrier, but we do not think it practicable to conduct such an inquiry into subjective intent. Essentially what the court is saying here, as later explained in the case of California versus Hodari, is that a seizure does not occur unless the officer portrays a show of authority and the suspect actually submits to it, or when physical force is applied. A consensual encounter, on the other hand, is not a seizure. Remember, it was Mr. Gutterman who first approached the officer, who pulled up with no flashing lights and did not raise her voice once, and when the officer asked for ID, Mr. Gutterman refused to provide it. Mr. Gutterman also continuously raised his voice over the officer, and at no point in this encounter was Mr. Gutterman told he was detained until here. A court could very easily conclude that Mr. Gutterman was not seized until this point, when the officer said he was detained, which was 5 minutes into the encounter.
So are you threatening me with arrest if I don't give you my ID? If you're giving me a threat of arrest and you want my ID...
I need to identify you, yes.
So under threat of arrest, are you...
I just need your ID.
Well, if you're not threatening arrest, then I'm not going to give you my ID. If you're telling me you're going to arrest me if I don't give it to you, I'll give it to you under duress. That's up to you. I know exactly what I'm doing, and I know what the law is, and you need to educate yourself before you make a big mistake for the Coeur d'Alene Police Department.
I'm waiting for my cover to come here before I do anything.
Okay. Well, I'm telling you, if you want my ID under threat of arrest, I will happily give it to you.
Well, you denied that, so...
No, I didn't deny anything. I'm telling you I'll give it to you. You're just creating it. You're on an ego power trip trying to make a scene out of something that doesn't exist.
I told you exactly how it works. I need to put you in our system that you are trespassing from the liquor store.
And what happens if I don't give you my ID? That's a reasonable question.
You're resisting.
So that's an arrestable offense.
It is an arrestable offense.
And would you arrest me for that?
I am waiting for a cover right now. I'm not going to argue with you.
I'm telling you, I will give you my ID if you're threatening me with arrest.
I'm not going to talk to you when you're arguing with me.
I'm trying to tell you that if you want my ID and you're telling me you're going to arrest me, I will give you my ID. That's not arguing.
Okay.
That's offering to comply with your demand, but you're obviously looking for a problem. And I'm not trying to give you one. I'm just trying to be a free individual standing up for my rights, and I know what my rights are.
The business wants you trespassed. And I knew who I was speaking to, so I could formally do that in our system.
Well, that's what I'm asking you. So if I don't give you my ID, are you going to arrest me?
I need your ID, please.
I'm asking you. If you don't, what will happen? If I don't give it to you, what's going to happen?
Dude, I told you right now, that's what I'm asking you to do. They want you formally trespassed from their store.
How are you?
Howdy.
Good. How are we doing?
Pretty good.
Good. Can I just ask name and badge number so I know I'm speaking to?
You're talking to her.
Okay. Well, she's refusing to answer my question.
You're talking to her.
Can I please have your ID?
I will give you my ID if you're threatening me with arrest.
I told you exactly what's happening. If you cannot do it, it's a resisting charge.
Okay, well, if you're telling me, you're telling me you're going to arrest me if I don't give you my ID, correct?
She's telling you she doesn't want to charge you with trespassing and obstructing.
So if I don't give you my ID, I will be arrested.
You will.
You just earned yourself a lawsuit. Happy day. Good for you.
Because I don't think you understand the law.
Oh, I understand the law very well. You don't.
So listen, they want you trespassed,
I just gave her my ID. End of story.
No, listen, they want you trespassed, right?
They have no lawful reason to ask me to be trespassed.
But they do. It's their business.
There's no lawful reason. This is state property. I'm standing here taking pictures. You're going to arrest me for taking photographs in public?
No. Listen,
yes.
It's their business, right? So they want you trespassed, meaning you can't come in.
That's fine, trespass, but you just earned yourself a lawsuit.
No, they want you trespassed.
No, you're going to. Well, you guys are the ones demanding my ID under threat of arrest. So now I'm going to sue you.
Facilitate it, right?
Well, now I'm going to sue you. You just facilitated a lawsuit against Coeur d'Alene, and I'm going to win. And that's the way that goes.
Mr. Gutterman consistently states that the officer's allegedly unconstitutional actions can cause a lawsuit against the city and the department, and that he will win in his lawsuit because of the officer's actions. This statement is a testament to Mr. Gutterman's legal knowledge, because as we will discuss, suing the city or department would be nearly impossible in this case. The common law doctrine of respondeat superior imposes vicarious liability upon an employer for the tortious acts of its employees. In other words, respondeat superior, which translates to, let the master answer, dictates that, when an employee wrongs a person, the person may file a lawsuit against the employer or business that employed him. This doctrine does not apply to constitutional violations, in part because it is only unconstitutional to actually commit an action that violates the Constitution. In other words, neither the city nor police department violate the Constitution simply because its employee violates the Constitution. According to Title 42 U.S. Code Section 1983, only the person who actually causes the constitutional violation may be sued. Under the Monell Rule, which was enunciated in the 1978 case of Monell v. Department of Social Services, a city or police department can only be sued under Section 1983 for a violation of the constitutional rights of others if they have implemented, by commission or omission, a policy or custom that results in the violation. For example, if the city or department is totally indifferent to the fact that it is allowing untrained officers on the street, this is an actionable claim, as the city or department's failure to train the officers was itself the sole cause of the officer's unconstitutional actions. But the simple fact that an officer violates a person's rights is insufficient to establish vicarious liability, especially where, as here, officers are indeed trained in people's constitutional rights.
And I'm going to name you personally, and I'm informing you right now that you're violating my rights.
Okay.
And I'm also informing you that you're violating my rights, so you're aware of that.
11-12.
You just violated my Fourth Amendment
rights.
Oh, I understand.
The business,
You
right?
don't know who I am. This is not a business. This is a public entity.
So you're saying they don't have the right to kick out people who are
only
being
if I'm
disruptive?
violating the law. I was not being disruptive. I was standing 20, 30 feet away from the doorway.
Well, I don't know what you were doing, but they want you
So why
trespassing.
would you accuse me of being disruptive if you don't know what I was doing?
Because-
it's all on 2 cameras.
Because they want you trespass, right?
No, they could want me sent
So-
to Mars. You're going to do that too? You have to follow the law, buddy. That's the way it works. Can I get a supervisor, please? I've asked 15 times. Or do I have to call 911 myself?
Do it.
You're not going to get a supervisor?
She's already called for one.
Okay.
The last minute, please.
How we doing, bud?
Not too bad. How are you?
Oh, pretty lousy right now.
Say if you had a
Yeah.
business, right?
It would be a private business, correct?
Open to the public, right?
No, it would be open to whoever I allow into my private business.
Okay, so what if
That's
it was
not the way it works. Private property and public property is a different story. Completely different story. Completely different set of rules. The only way you could
So the
trespass
liquor
me,
store-
the only way you could trespass me off of public property is if I've committed a crime. You cannot trespass someone from public property when they have committed no crime. That's the way that works. You're going to learn the law today. You're making a mistake.
Mr. Gutterman states that you cannot be trespassed from public property unless you have broken the law. This must mean one of 2 things. Either minors cannot be trespassed from a liquor store, or the government can make entering onto public property a crime depending on age. Either all people are permitted onto a military base or the government can close off any public property simply by posting signs that say no trespassing. This problematic ideology arises from the fact that Mr. Gutterman believes all private property is governed by one set of rules and all public property by another set of rules. In reality, neither of these are true. As stated previously, a self-identifying journalist has no greater right to access public property than the general public does. In the case of Press Enterprise versus Superior Court of California, the U.S. Supreme Court ruled that the First Amendment grants the public a qualified right of access to criminal trial and pretrial proceedings. In reaching this conclusion, the court noted that a qualified right of access exists when the place and process has historically been open to the press and general public, and public access plays a significant positive role in the functioning of the particular process in question. The second prong of this test makes clear that the public only has the right to access the property if the public's access is in accordance with the function or purpose of the place at issue. However, Mr. Gutterman's presence is irrelevant to the purpose of the liquor store, which is to sell intoxicating beverages. Rather, his purpose was to film, which is not the purpose or function of the particular place in question at all. In Index Newspapers versus U.S. Marshals, the United States Court of Appeals for the Ninth Circuit stated, "The press enterprise test is not limited to any particular type of plaintiff or any particular type of forum. Because he was engaging in speech and press-related activity irrelevant to the purpose of the liquor store, the public forum test is the test that must be used." As the Ninth Circuit said in the Saved magazine case, the relevant inquiry was ultimately the free speech test, not the public access test. Having decided that, we move on to the public forum analysis. In Perry Education Association versus Perry Local Educators Association, the Supreme Court identified 3 types of forums. Traditional public forums include places in which people have historically had a right to engage in public discourse. Designated forums are places designated for that purpose, and non-public forums are parts of public property that fall into neither category. The Ninth Circuit has also used cases like Rosenberger versus University of Virginia to conclude that limited public forums are a subclass of designated forums that are open to speech-related activity, but limited to specified topics. In order for any piece of public property to be considered a public forum, it must specifically be open for the purpose of speech-related activity, either by historical tradition or designation. In the case of Greer versus Spock, for example, the court ruled restrictions on speech were valid on a military base because, as they said, it is consequently the business of a military installation like Fort Dix to train soldiers, not to provide a public forum. Similarly, the purpose of a liquor store is to sell liquors, not to engage in speech. Under these circumstances, the Perry case dictates that the Gutterman's removal from the premises be viewpoint neutral. Since recording is a method of communication, not a topic or even a view, there is no evidence that they were treated poorly based solely on their viewpoint. Consequently, their removal from the premises was almost certainly constitutional. And while state law itself does not prohibit filming people in public, the U.S. Supreme Court in Adderly versus Florida said, the state, no less than a private owner of property, has power to preserve the property under its control for the use to which it is lawfully dedicated. Title 18 Chapter 70, Section 08 of the Idaho Statutes makes it a crime to remain on the property of another after being told by the one in charge to leave. In State versus Pentico, the Idaho Court of Appeals upheld a trespass conviction against a man, even though the land he entered was public property, because of the reasoning in Adderly and this statute. Just because state law does not prohibit filming in public does not mean it allows a trespass onto public property. Therefore, by Mr. Gutterman's refusal to leave the property when ordered to, the police would be well within their authority to arrest him.
And I tried to be civil with her, and I tried to have a conversation. She's just running her little ego trip, and that's what she wants to do because she feels like she's got a gun and a badge and she can order people around. This is not the way the world works. This is not the way the Constitution of the United States works. You people swore an oath to the Constitution, and you swore an oath to protect my rights. And now you've just violated my First Amendment right and my Fourth Amendment right. And you're going to learn that from a judge in court.
Shortly after this heated discussion ended, the officers left the scene without actually solving the issue. Even though the Guttermans were on the property for a while before the police arrived, they departed immediately after the officers left, leaving the impression that their only goal was to get a reaction from the police. Mr. Gutterman also stated he would attempt to file a lawsuit against them, though he said that in multiple videos and has only followed through with relatively few of these claims, which were settled outside of court. He also mentions how it was difficult to find an attorney to litigate these claims. Overall, the Guttermans get an F. They displayed extremely unprofessional behaviors by yelling over the officers, cutting them off, and refusing to listen to their side of the story. He displayed a major lack of understanding of trespass law, freedom of access, free speech, and vicarious liability under Section 1983. He also lied to the officers several times throughout the encounter. Example.
Hey guys,
Yes, sir.
you can film out in the parking lot, but you gotta get off our property.
First of all, let me have a conversation with you. I was not asked.
Right, can I get a cover?
I was not asked to leave. Okay.
Okay, well, they can decide not to let you inside the business. But you're right, it's a state property, so being on the property isn't necessarily criminal, but they can refuse service to anybody because they are a business.
Right. Well, I never went inside the property, in the building. I was outside in the parking lot the entire time.
The officers get a B-. Although they were calm and collective throughout the encounter and never violated the Constitution, they ultimately wasted taxpayers' time and money by rushing to an area where the Guttermans clearly had no constitutional right to be, only to end up leaving without actually solving the issue. Their failure to thoroughly do their job and instead engage in pointless squabbling raises questions about the effectiveness of their department.